myself, both Oklahoma City and Tulsa, and we provide services to people who are blind or low vision all across the state. But I'm slightly different than NewView's mission, and that is I operate a division. Our exclusive domain is the area of digital communications accessibility, and I'll talk a little bit about what that is in a minute. But we do provide services to businesses, large and small. We do work with federal agencies. The Department of Housing and Urban Development is one of our clients. We have state agencies, the Department of Human Services, Department of Education are clients of ours. And then we also do work with large and small businesses, as small as one-man shops all the way up to several hundred multi-state operations. So we have a broad range of folks who are very interested in making their web assets or their digital assets more accessible. So what is a website accessibility? What does that really mean? Does that mean, as it would imply, that it's only about my website, that I have to make sure my website is accessible? Well, your website is an easy target, if you will. I mean, it's easy to think about a website. We all have them. But really, it is any form of a digital asset. So if you have websites, have web applications, if you do businesses in conventions and you have kiosks, if you have documents, usually in the form of PDF documents on your website or anywhere for that matter, all of those are digital assets. And the law is equal to all of them. They all must be made accessible and usable to people with disabilities. And I'll describe a little bit difference between accessibility and usability. So why is it important? Why are we really concerned about that? Well, the most important reason is it's good for business. You know, you all have a front door to your business. You all invite people into your business. You want them to have a great experience when they come to your business. And you hope that they will come back over and over again and spread the word about how great you are, how satisfied they were, and do business with you, meaning that they have a monetary exchange with you. The same is true with your website. Your website is the front door of your business. Probably more people visit you on the website before they ever walk in your front door. So it is universal. You don't meet anybody today but what you then go and check out their message and where it is and more about their business, more about how that business might relate to you. So in a sense, they are a virtual visitor in your business, and you may get far more traffic there than you ever get in the front door of your business. Certainly after the result of COVID, so much more business went online and so much more business traffic occurs there also. So if you're in the world of e-commerce, and almost everybody is, you are definitely involved with digital communications accessibility. Well, then the question is, who does it impact? If we have these digital assets, who's impacted by that? Well, the simple answer is your business, certainly, your traffic in your business. But the most important thing is there are 600,000 and more people with disabilities in the state of Oklahoma. It's a huge population. And like Brett said about veterans, people with disabilities also have a giant spending habit. So they are just as likely as anybody else to traffic your business. 1 in 7 families in Oklahoma has a person in or a relative nearby that has a disability, and so those families are equally impacted by their ability to enter your front door, enter your website. But there's also another why of the website, and that is because it's required by law. So not only is it the good thing to do to be a good steward of your business, but it's also required. And as Jill mentioned, there are laws. There are multiple laws actually that occur in Oklahoma. There is the state law or the federal law everybody recognizes, the Americans with Disabilities Act, which until not too many years ago was somewhat ambivalent on the area of website accessibility. But then it has been determined in courts that businesses or government entities, but primarily businesses under Title III of the ADA, are places of public accommodation. And your website has been deemed the same thing. So it's almost like there was a requirement, now it isn't, that it be bricks and mortar, that your website was required to be accessible. Today, it's not. You are a public place of public accommodation, so is your website. It is required to be accessible. But beyond the ADA and more direct to the area of digital communications, there's another law that really supersedes it. It's called the Oklahoma Electronic Information and Technology Accessibility Act. So Oklahoma has its own version of technology application. It is a direct mirror of another federal law, Section 508 of the Rehabilitation Act. It's almost word for word, but it does specifically address the notion of accessibility, digital accessibility in the state of Oklahoma. A lot of people, maybe Alyssa could speak to that, a lot of people, business leaders, web developers, don't realize that that law exists. And so it's not just that you have to be compliant with the ADA, you also have to be compliant with OEITA. So those are very critical. So there are numerous myths associated with web accessibility or digital asset accessibility. There are a lot of misunderstandings or misbeliefs. So I'll touch on a few of them here. Let's go to websites first, and that is a lot of people think, well, I am a very, very small business. I'm a one-man shop or a two-man shop. So do I really have to have a website that's accessible? The answer is yes. If you have a website, it's got to be made accessible. You're not out of the law, beyond the law, under the law. You're directly a target. A lot of small businesses particularly traffic using e-commerce. And I will tell you today that e-commerce businesses are the #1 targets that we see in terms of accessibility lawsuits. So small businesses. What if you didn't develop your website? What if you bought a template? Or what if you had a third-party developer develop your website? Certainly, the template manufacturer or the third-party developer would be responsible for the accuracy or the compliance of your website. That's not true either. The fact of the matter is, it's your website. The content of the website is your responsibility. Now, you may have a contractual relationship with your developer that maybe they assume liability or you've transferred liability to them. But generally speaking, if it's on your website, be it a document or be it a web asset, that it has got to be made accessible. Another one is documents. And a PDF document or any other form of digital document, such as invoices and statements and notices and safety bulletins and those types of things, need to be made accessible. But what if you did not originate the document? What if it's somebody else's? This is similar to your website. If your website, for example, if you're a retail store and someone manufactured the products or items that are in your store, be it a digital store or a real store, they are required to be accessible as well, even if you did not author them. So if you have a document, you've got an application form that comes from one of your vendors, you've got a display of jewelry and it's available through e-commerce, that also is required. It's on your website, it's your responsibility. There are things you can do about that. There are disclaimers. The two actions you should take. #1 is to notify the author of that document or author of that exhibit or product that it has been deemed not to be accessible, and could they please modify that. So, and you want to keep a record of that in your file as well. The second one is have a disclaimer on your website, and I'm going to talk about that in a minute. So the other thing is documents, and that is, give you a great example. The Department of Commerce right now is looking for publishers to create textbooks. Right this year, they're doing it for next year, and for this year, the books they're selecting are in the area of primary education and math for the remainder of school years. One of their publishers in the area of early education has told them that because it is primarily for kids under the grade of 3 and below, that it doesn't need to be made accessible. And then again, I'll go back to the principle of accessibility, and that it applies equally to everyone. So a kindergartner, if they're using a textbook or a digital piece of communication, or even a hard copy piece of information for that matter, it's got to be made accessible. And you get into area of fairness in education that way too, and that is a school can't say, we can provide a reasonable accommodation. All that student needs to do is ask for us to develop a reasonable accommodation. The accommodation might be that we could provide a book in Braille, for example, or large print, or we could provide a computer with screen reader technology built in, or zoom text so that a person with low vision can have a large modified text. But the fact of the matter is that it's got to be made accessible. Another myth is that if I didn't author the document, it doesn't need to be accessible. I'm just simply passing on something from somebody else. Well, think about that for a minute. If it's an application for something, the application is also benefiting your business, but you own it, even if you didn't author it. So it's got to be made accessible. So there are a lot of myths that we hear all around Oklahoma about why they don't need to be accessible. But the fact of the matter is, if it's a digital asset and you own it, you're responsible for it. How you manage that is slightly different. So then I would kind of wind up by saying there are some things you could do today, some things that don't cost any money at all, and here's what they are. Number one is, if you use what we call an overlay on your website, get rid of it immediately. An overlay is a piece of code that a supplier has provided, and you install the code on your website, and the website, in theory, then becomes automatically and magically accessible. And there's all kinds of claims by the overlay manufacturers and distributors that it does a complete job, that it's 100% accessible. But the fact of the matter is that code on your website, your actual code, has not been changed. And in many cases, the use of an overlay interferes with a screen reader technology. So a person who is blind or has low vision that comes to your website using a screen reader, which is a form of technology that actually reads the content of your website and it transfers it audibly into the ears of a user, the actual code is not only not accessible, but it may actually harm the person's software who is using that screen reader. So please, if you'd like more information, I could provide numerous article and text third-party testimonials about why they don't work. So the simple fact is they don't, and my best recommendation for you is get rid of them if you have them. So the second thing is, and this is again a relatively low cost or even no cost, and that is prepare and list an accessibility statement on your website. The accessibility statement is probably one of the most powerful things you could do as first steps in reducing a claim. Accessibility statements can be as long or as simple as you'd like them to be, but there are three elements that you have to make sure that you include. First is your willingness to accommodate people with disabilities, your commitment to making your digital assets accessible and usable by everyone. And then the second step is to make sure you cite the reference or the laws that you're referring to or guidelines that you're following to make your website accessible. Typically, the guidelines that are used today are called Web Content Accessibility Guidelines, typically referred to by acronym WCAG, WCAG, and the current standards of WCAG that are mandated are 2.1. So it's WCAG 2.1 is the standard. Now, if you use something like an Adobe Acrobat, and a lot of people do, and a lot of developers recommend that you do, what you have is a software that will convert a document to a PDF, and it will comply with the PDF checker of accessibility through Adobe. The problem is that even though it's technically accessible, it may not be necessarily usable. Technically, the words, phrases, sentence, and the the hierarchy of location of those words or paragraphs may be completely in order, so it's 100% accessible. The problem is that, for example, websites have got to be made accessible for everyone, mobility, sensory, and cognitive disabilities. So if there's a paragraph or a sentence that is not understandable, maybe there's a misspelling, maybe there's a series of acronyms, maybe there are all kinds of concepts that make that part of your document not understandable, very complex, run-on, or heavy use of footnotes, for example, it may make it very difficult for a person who has a traumatic brain injury or has had a stroke to really understand the content that you're trying to provide. So it has to also comply with WCAG guidelines that make sure it's accommodating people with all forms of disabilities. The third thing that has to be done in the accessibility guidelines, it provides a visitor to your site the means of contacting you if they really can't use the entire site. So they're contacting you, they're hopefully contacting a specific person within your company, saying that they can't do that and you've said you're committed to it, can you help me? So you're offering to provide a reasonable accommodation for that visitor. There are a lot of different ways that you can provide that accommodation. You could visit with a person in person. You could talk to them over the phone. You could have a text interchange of communications to try to give them an alternate form of participating in that particular aspect of their business. So the third form is just that, the offer of a reasonable accommodation via a specific telephone number or a web address, an email address, and hopefully by name, by an individual that a member of the public can contact if they need a reasonable accommodation to really navigate your web assets. The person's name that you assign this, and I've had it happen all the time, is that maybe they're no longer in your business, and yet you've got this name and your switchboard doesn't know where to put that call. Another thing is that the person whose name has been provided doesn't know anything about accessibility. So when a person calls and says, my son, daughter, brother, friend has this form of a disability, can we do this? Can we read this? Can you read that to us? The person receiving that call, if it's a front desk switchboard or if it's been switched to an inadvertent person, may not have any idea how to appropriately respond to that person and provide the accommodation they're looking for. And the very last form of recommendation I would have is listen to DOJ guidelines. Department of Justice is kind of the master in terms of managing lawsuits or demands that made by people with disabilities against anybody in any form of a disability. The DOJ guidelines are really, really simple. It's just 3 steps. Number one, and this is incredibly important, and that is have a professional review of your website. And that is done by either using an automated scanning, which will identify 20 to 30% of the potential errors on your site, or best is to have someone conduct a manual audit, someone who's using a screen reader, working alongside possibly a person who's sighted to really thoroughly examine the typical pathway of your customer through their website or through other digital assets. The second part of that is after you've done an identification and evaluation of any deficiencies or non-compliant issues you've got, make sure that you make a record of those findings. The record has got to be available to you, and then from that you need to have a plan of action. What are you going to do to remedy those non-compliant issues? Now, when I say what are you going to do, it has to be a defined plan. It's got to have a defined timeline. You're going to get it done by when, and then the other part is by who. If you're assigning that responsibility in your company, make sure that you have a kind of a written record of that, and that person who's been assigned the responsibility really knows how to manage that task in order to get it completed. The third action under DOJ is that now you've got a plan. Now, and the plan, by the way, does not have to be accomplished immediately. It's like there's a huge burden. It's going to take thousands of dollars to remedy all these deficiencies on my site. My gosh, I can't afford that now. How do I possibly manage this? Well, you've got time. You can manage the remedy actions over time. So it may be that if you have 100 deficiencies, for example, you can take the first 10 or the most important 10, and in the identification and evaluation of your website, you should be able to get a very clear list of defined priorities of these deficiencies. So you say, well, I'll tackle the first 5, or I'll tackle the first 10, and I'm going to be managing. My plan is that I'm going to be managing the remediation over a period of time, and that time could be months, it could be a year. In some cases, if you have a large business, a tremendous number of violations, it could be longer than that. So long as you have identification, evaluation, a plan to do something about it by definition, by written plan, and the third thing is that you are taking meaningful action to remedy that plan. Now remember that your website is dynamic, so this is never once and done. You know, your website is being changed almost daily. Your documents have been increasing and decreasing. Another word, and I hate to go back on this, but another word about documents is most people don't have any idea how many documents they've got on their website. You know, if I talk to most businesses, we say, I don't think we have any documents. I had a law firm recently who said the same thing. I've got 3 or 4 locations around the country, and they said, we're very protective. We don't have any documents on the public side of our website. Well, we did a quick scan of their website, and we found several hundred documents that were public-facing documents. So the reality is most businesses don't know, do we have 5 or do we have 50 that are hanging on our website? Another myth that they've got is if we don't have them public-facing, in other words, if a visitor comes in and they don't see any documents, then we don't have to worry. We're going to keep them all inside, behind the firewall of the website, and we'll make them available on demand. Wrong again. If you use documents, and wherever they're located, they're required to be accessible, even if the document is communication inside your company. So again, you can't always assume that you don't have or won't have a person with a disability being employed by your company. More than likely, you do have more people with disabilities than you think, or a person who could get a disability or become disabled than you think. You have anybody over the age of 40 or 50, they're beginning to lose eyesight or modifying eyesight. They're beginning to have a different ability to hear. So all these things are merging disabilities that could be very, very valuable inside your company, and you have a responsibility to also communicate intercompany as well. So the 3 things from DOJ: have a thorough identification and evaluation of your website to determine the non-compliant issues. Develop a plan of action to do something about it, and that could be kind of a top to bottom in your company. Who's going to be responsible for this action? Who communicates the responsibility at your regular meetings? And then lastly, what are you doing? And how are you monitoring what you're doing? So what is your plan of action? And are you working? So with that, I will stop and let my colleague Alyssa talk a little bit about the remainder of ADA and other accessibility issues. Thanks.